2.5 million rand bribe allegations.
2.5 million rand bribe. Why Katiso Molefe was granted bail by the same court that denied Matlala bail. General Mkhwanazi was right. Imagine a system where the scales of justice are tilted not by evidence, but by wealth. This is the reality unfolding in South Africa, where a striking difference has emerged in how two powerful figures, accused of serious crimes, have been treated by the same High Court. Katiso Molefe, a multimillionaire facing multiple murder charges, has walked free on bail after being asked to pay 400,000 rand for his bail, while Vusimuzi Matlala, another businessman linked to attempted killings, remains behind bars after his appeal failed. This contrast confirms what KwaZulu-Natal Provincial Police Commissioner, Lieutenant General Madlanga Mkhwanazi told South Africa in his national briefing, that a Gauteng drug cartel has captured the government, the police, and the justice system.
Confirm before the South Africans today that the investigation which these members were involved with in Gauteng has unmasked the syndicate. And this syndicate involves, amongst others, politicians who are currently serving in parliament. The law enforcement officers include the members of the South African Police Service, the Metro Police, and correctional services. They include prosecutors in Gauteng province, the judiciary, and all these are controlled by the drug cartel as well as business people in that province of Gauteng.
Under normal circumstances, neither Molefe nor Matlala should have seen the outside of a prison cell so easily, given the weight of their cases and the risks they pose, as indicated by the lower courts that denied them bail. Yet, Molefe's release has sparked allegations of a massive 2.5 million rand bribe, suggesting that money may have tipped the scales in his favor, overriding what should have been a consistent denial of freedom. Let's look at the crimes that landed these two deadly men in court. Molefe stands accused of orchestrating the killing of Vereniging engineer Armand Swart in April of last year. Investigators have also connected him to the deaths of popular musician Opa DJ Somebody Sefoga and businessman Hector DJ Vintos Buteliers. These are not isolated incidents. Molefe is said to be part of a larger group known as the Big Five cartel, which deals in securing public tenders through shady means, along with other illegal activities like distributing controlled substances and handling cross-border vehicle thefts. His past adds even more layers to the concern. 2 decades ago, while abroad in the United Kingdom, Molefe was caught with a fake passport that listed false names and birth dates. At the time of that arrest, authorities found him in possession of a firearm and cannabis, leading to a conviction that still haunts his record today. Prosecutors argue this history shows he cannot be trusted, especially since he has used false identities before, making him a clear risk to flee if given the chance. Matlala's situation mirrors Molefe's in many ways, which makes the different outcomes all the more puzzling. He faces charges for attempting to end the life of his former partner, Teboko Tsobetshe, back in 2023. The state plans to add more counts related to failed attempts on taxi operator Joe Sibanyoni and entertainer Sunkie DJ Vetis Mogubu. Like Molefe, Matlala is tied to the same Big Five cartel, with accusations of pulling strings in the criminal justice system to protect their operations. His own criminal background includes a conviction from 2001 for breaking into a home and stealing property, a detail that courts have weighed heavily against him. During a major press briefing in July by KwaZulu-Natal's top police official, Lieutenant General Madlanga Mkhwanazi, Matlala's name came up as a key player in efforts to influence law enforcement and prosecutions across the country. Both men first sought bail in lower courts, where magistrates turned them down without hesitation. For Molefe, the Alexandra Magistrate's Court in Johannesburg ruled that the evidence against him was too strong, pointing to his role in the Swart killing and his links to other deaths. The court highlighted the danger he might pose if released, including the possibility of tampering with witnesses or disappearing using his resources and past experience with fake documents. Matlala faced a similar rejection in the same regional court. Magistrate Saita Prinsloo examined the details carefully, noting the seriousness of the charges and Matlala's potential to interfere in the case. She considered his family ties, business interests, assets, and even his old conviction, but ultimately decided he represented a flight risk and a threat to public safety. The state opposed his release, citing unlawful phone use from prison and the strength of their evidence, which includes disputes over facts that would need testing in a full trial.
That cell phone in prison is a means to communicate to the outside world. And that is a risk to the state's witnesses. That is a major risk, as it is, my lord, by the very nature of these crimes. By the very nature, these witnesses are in fear for their lives, and rightfully so. So, my lord, the fact is that the behavior of the appellant is not that impeccable.
These lower court decisions seem straightforward, based on solid legal grounds without any sign of bias. The magistrates applied the law evenly, recognizing that both Molefe and Matlala are not first-time offenders and that their alleged actions involve high-stakes crimes with widespread impact. If anything, these rulings showed the system working as it should, prioritizing public protection over personal influence. However, the appeals to the Gauteng High Court in Johannesburg took dramatically different paths, fueling suspicions that something unfair occurred behind the scenes. For Matlala, acting Judge Peter du Plessis handled the appeal and upheld the denial just days ago. He reviewed the magistrate's work and agreed with most of it, even though he spotted a small error in how the bail category was classified. The case fell under Schedule 5 of the Criminal Procedure Act, meaning Matlala needed to prove his release served the interests of justice, not the stricter exceptional circumstances of Schedule 6. Despite this mix-up, du Plessis found the core reasons sound. Matlala has the means to flee, a motive to disrupt witnesses, and a real chance of endangering the community. The judge pointed out risks like potential obstruction of justice and harm to those involved in the case. He even addressed Matlala's complaint about two co-accused, Musagegana and Tleko Floyd Mabusela, who had been released on warnings in this matter but are now detained for the Swart murder. Du Plessis acknowledged the appearance of uneven treatment but noted it stemmed from the state's choices, not court favoritism. In the end, he concluded that freeing Matlala would not align with justice, keeping him in custody until his next court date on November 11th.
The NPA welcomes the dismissal of Vusimuzi Matlala's bail appeal by the High Court of South Africa Gauteng Division in Johannesburg. We are of the view that the court made the right decision in denying Mr. Matlala bail, considering the severity of the charges and the risk to public safety, as well as law enforcement officers, including the investigating officer and the prosecutors involved in this matter.
Molefe's appeal, however, ended in success 2 weeks ago, with the High Court granting him 400,000 rand bail under conditions that investigators find suspiciously lenient. Judge Brad Wanless, in his ruling, stated that the state's reasons for denying bail lacked solid backing, allowing Molefe to go free without even requiring him to report regularly to a police station, a standard measure that the judge called an unnecessary burden.
The appellant is granted bail in the amount of 400,000 rand, full stop. This amount is in addition to the bail granted by the High Court of South Africa, Gauteng Division, in brackets Pretoria, under case number capital letter A 112/2025 in the sum of 100,000 rand.
This decision overlooked key red flags, such as Molefe's UK conviction and his history with fraudulent passports, which he only disclosed late in the process after seeing the prosecution's arguments. Prosecutors had pushed hard, emphasizing his flight risk and the strength of evidence tying him to the murders, but these points were dismissed with minimal explanation. Wanless mentioned exceptional circumstances but failed to detail them fully, leaving the judgment thinly reasoned and open to criticism from legal experts who say it lacks the depth expected in such urgent matters.
A disappointing outcome, of course. We were not expecting such an outcome. However, as the NPA, we take it on the chin and we move forward in terms of studying the judgment of the court and to determine or craft a strategy in terms of dealing with the matter going forward.
This is where the allegations of corruption enter the picture, brought to light during recent hearings at the Madlanga Commission of Inquiry into Criminality, Political Interference, and Corruption in the Criminal Justice System. On October 21st, a Gauteng detective known as Witness A, who was part of the political killings task team that arrested Molefe for the Swart murder, testified about tips from informers. These sources claimed Molefe arranged a 2.5 million payment to secure his release, with the information circulating among investigators even before the court date. Witness A described how his team had been notified in advance that bail was coming, pointing to possible involvement from within the judiciary or prosecution. While no hard evidence was presented, the detective highlighted inconsistencies in the High Court's handling, like downplaying Molefe's past and rejecting basic reporting requirements.
This day now was the day which was given to us by the prosecutor that was dealing with the appeal. Then he told us that the appeal will be held in Pretoria High Court. Then he gave us the courtroom number, and then he asked if we would like to attend the court. Then we did. But maybe I just should mention that prior to this bail, we had already received information from informers and sources to say Katiso Molefe will get bail. They went as far as giving the figures as to how much he's going to pay for his way. But now that information will be dealt with more by Witness B. What I just wanted to highlight here is that at the back of our mind when we went to the courtroom, we already knew that this is what has been said to us. And then we didn't know if it was going to transpire the way they said it or not. We also raised it with our commanders to say this is the information that we received as a team, to say this man is going to get bail, and then this is how much he paid for his bail. But not paying now bail money, I'm saying paying the process of him to be giving bail against all odds, which then was talking to corruption from the system. We didn't understand exactly if this system was going to be in the judiciary, like the justice system, or the NPA, because we're now dealing with the NPA. We just started trying to establish a relationship with the new NPA personnel, the prosecutor. We didn't understand him that much. Is it him who is going to receive this, or is it going to be the judge? We didn't even know the judge. But now we were told that this is what is going to happen, and then this is the figure that is going to be paid for him to get bail. Not the figure to say this is how much that you need to pay for you to get bail, but this is what you will have to pay for you to get to be admitted to bail, if I'm making it clear to the commissioner.
I'm sorry. I know you're still going to come to it, but was the figure eventually, or at which bail was eventually fixed?
Another investigator, Witness B, added more details in her testimony, expressing discomfort during the proceedings and a sense that the outcome felt prearranged. She had even sought permission to leave the courtroom, troubled by what she saw as inadequate scrutiny of Molefe's risks.
I was very uncomfortable with what was transpiring. In particular, it felt to me that the judge had already predetermined the matter. Although this is not uncommon, it seemed he was also intent on giving Mr. Molefe, who was accused of very serious offenses, lenient bail conditions. In particular, two exchanges are relevant. Before I deal with subparagraph Witness B, can you confirm this paragraph?
Yes, I confirm, Commissioners.
With this correction, perhaps Witness B, it's acting Judge President, not acting Deputy.
Noted, Commissioner will be rectifying that.
At paragraph 116.1, in one of the exchanges related to the conditions related to Mr. Molefe's movement, Mr. Molefe's lawyer asked for movement within the Gauteng province or even house arrest. The judge of his own accord inquired whether that would not be too restrictive, as Mr. Molefe had businesses in other provinces. Mr. Molefe's lawyer responded that she does a number of these matters where there are business-related reasons for travel. These would be communicated and written permission of the investigating officer would be sought, which cannot unreasonably be withheld. The judge then raised the issue of the child and girlfriend who live in KZN, to which Mr. Molefe's lawyer responded that they can travel. Despite Mr. Molefe's lawyer's acceptance of this well-established condition, the judge made a comment that bail should not be a punishment. In the end, the bail condition granted was basically that Mr. Molefe can leave after informing the IO, and the IO should not object unless there is a valid reason. Witness B, can you confirm this paragraph?
Yes, Commissioners, I can confirm this one. And maybe to have some comments on this one.
Yes, Witness B, you can continue.
My main concerns in what the judge expressed there is to say if this would not be too restrictive. I felt like he was already showing the signs of lenient towards the accused, because the accused was the one applying, and he already placed on record what he's willing to take, but the judge is the one who feels it's too restrictive. I felt like the judge is having too much lenient towards the accused, and that's where I already knew that he was going to be granted bail already. When the judge said it will be a burden on Mr. Molefe, I felt all the pain that came with the burden, given the fact that he was proposing that he wouldn't mind to do it, but the judge is the one who feel it will be a burden. It was an agony for me to sit in that court now listening to all this, because I already knew the verdict while sitting there. So to sit there further, it was really a pain to me. I even went out, made a phone call to my commanders to say, can I please withdraw? I can't sit here any longer, because it was a pain. But they said, feel all the pain that you feel. We need a feedback.
Thank you, Witness B. Commissioners, the exchange Witness B is referring to can be found at CJC 4.5, and that is at page 323, line 20, until page 324 at line 8. Paragraph 116.3. The judge took the view that Mr. Molefe had been candid about his past conviction when he had in fact not. As set out above, he only addressed his previous drug-related conviction and the fact that he was traveling with fake papers when he saw the state's opposing papers in his bail application in the Magistrate Court. The judge accepted the version that Mr. Molefe made the disclosure to his previous representative. Moreover, from the interaction, It was clear to me that the judge did not have an interest in the conviction because it was 20 years old and it thus carried little weight. Witness B, can you confirm this paragraph and provide commentary, if any?
I happy with the way it has been read on record. I have no further comment.
Commissioners, and reference to this interaction is at CJC 4.5, page 331, line 11, until 332, line 11. Paragraph 117. Nevertheless, Mr. Molefe was granted bail of 100,000 rand with conditions that are questionable. In particular, he was ordered that 2.1, he should report to the nearest police station twice per week on a Monday and a Thursday. 2.2, he should be in the province of Gauteng and can only leave Gauteng province after informing the investigating officer in writing where he would be going, and the investigating officer would not object unless there is a valid reason for him or her to object. 3.2, the applicant should interfere or communicate with the state witness mentioned in the indictment.
Yes, the motive, yeah. Hence, I reference to the 12th. We say we see something common about the dates, the 12th, because the 12th is when now, like, he was pressured to give the documents, and knowing that there was manipulation in this, and that to have costed him his job and everything that he worked for. And then instead he reached out to the uncle, and the uncle called out to the friend, and they both start scouting as immediately as the 12th, because the 12th is the genesis of why we are here now.
Witness B, what's your belief that Mr. Molefe ordered the hit based on?
It's based on this SK tender and the whistleblower, because, Commissioner, the actual person that was intended to be killed here is the whistleblower that was blowing the information in this SK tender thing. So unfortunately, we find Mr. Swart being killed, but not the person that was intended to be killed, because now it was creating problems for Lucky at work now that the investigator was busy now needing to have these documents, and the same documents was going to reveal that these two companies that he said they were in competition with SK, they actually non-existent. And the SK itself, it has its own problems, because the investigation has revealed that even there it was a pawn in Blacky Molefe and Thapelo Molefe, who's the son to Katiso Molefe's pawn, because when the money was paid now, maybe I don't know if I'm going too forward, but when the money was paid now to this SK, what happens, it gets paid to SK account, but the whole amount is transferred to Thapelo Molefe's account, and Thapelo Molefe is the one paying people, including the so-called director of SK. He's getting as little as 30,000 out of 1.2.
The Commission's revelations have prompted responses from top judicial figures. Chief Justice Mendisa Meyer issued a statement calling the claims untested but potentially harmful to public trust. She urged anyone with proof to file a formal complaint with the Judicial Conduct Committee, the proper body for probing judge misconduct. Meyer discussed the matter with Acting Judge President Aubrey Ledwaba, who has been linked to the allegations, though it's unclear if the money was meant for him or others. Ledwaba denies any wrongdoing, refusing special leave and planning to share his side at the Commission.
Given that he had a discussion with the Chief Justice and it does seem that she would have preferred him to take special leave. I think there is an argument that he should have done so. The difficulty here is simply that at this point there is no allegation in front of the JSC. There's no complaint. What there is a statement and a commission of inquiry. Obviously that's a serious thing. It's a statement that was made under oath. It's certainly more than just a rumor or gossip, and so we do have to take it seriously. But what I'm certainly worried about is the fact that there is no complaint in front of the JSC at this point.
Thanks for watching.